When parties approach court with an agreement, it is not that the court is duty bound to take up that agreement. Before court takes up the agreement, the court is going to consider few important aspects, like whether the agreement is duly executed, whether it has been done properly, all the requirements of Contract Act has been fulfilled, whether the parties have got a bona fide interest in the question stated. Please remember, court is not interested in answering academic questions, they are only going to take up bona fide interested questions. Thirdly, and very importantly, court also considers whether it is a matter to be decided by it, fit to be decided by it, and once it is satisfied that all the requirements are fulfilled, it shall pronounce the judgment, and following the judgment there will be a decree. So, when an agreement is brought before the court, when the court puts it to its testing procedure, when the agreement passes the test, there would be a decree, there would be a judgment, and that is going to be binding on the parties forever, and most importantly, no appeal against that provision. Upon decision by the court, what kind of decisions the court can pass under this special suit, which is so friendly in nature? It can pass an order that a payment shall be made by one party to the other, if that is the question to be decided, whether a party entitled for a property, either movable or immovable, or whether the party is entitled from refrained from doing certain act, refrain from construction, so refrain from interfering. So, all these issues could be resolved through intervention of a court in a friendly manner. I find that is a dispute, that is a solution which is speedy, amicable as well as long lasting. The only issue here is it is amicable because parties are presenting as one, not as an opposing parties. Court is taking up it as a matter to be decided rather than dispute to be resolved. Moving from this special friendly nature of the suit to the next, it is summary procedure. So, when we talk about summary procedure, take an example that A extends a loan to B, and while extending the loan he takes an undertaking in a writing that so much of money is extended on so much of interest on so and so date. So, when a document exists regarding extension of loan and the same is been produced before the court calls it as summary proceedings and direct the defendant to decide to pay the amount. See, the payment order of payment is made instantly. So, this is summary procedure. Now, when I say summary procedure, it is quite different from ordinary procedure. What happens in ordinary procedure is a plaint is submitted. In response to the plaint, summons is issued by the court. When the defendant receives the summons, he writes his reply to the plaint and that becomes written statement. So, once plaint written statements are filed, court springs into action, sits and lists out the issues to be decided in the litigation. So, once issues are framed, it is followed by trial proceedings. During trial, you may ask for some interim measures, protection of subject matter, these are all on the necessity based. And finally, a decree or judgment would be pronounced by the court. What happens in summary proceedings is, it is some of the important stages of a regular suit proceedings has been skipped, like plaint is filed, judgment is pronounced. It is not this simple, but this is what is expected in a summary procedure. So, what happens here is, once a plaint is filed and summary proceedings are demanded by the plaintiff, what plaintiff is demanding is the defendant should have no right to defend. So, he has no right to file a written statement, he has no right to defend, but at the same time, as provision of fair hearing is binding on the court, the court would give one opportunity to the defendant to establish that why he should be heard. So, first he will file an affidavit stating that he should be heard, and he seeks permission from the court to be heard. So, when the permission can be granted on sufficient grounds, or maybe a plaintiff has not established certain important aspects of the deed, then the court will grant the permission to be heard. What is to be considered here is it is an additional procedure as to where defendant has to prove about his right of hearing, but predominantly in the proceedings before court, which is summary, plaintiff files a plaint, defendant has no right of defense. So, here why this summary proceedings have been invented? Do not you think that it causes injustice to the defendant who does not have a right to defend? So, to answer this question, I must say that legislature have put in lot of thinking into classifying the disputes where the summary proceedings could be ordered. The disputes where summary proceedings are suggested are disputes relating to bill of exchange, where documentary evidence are complete, full. Promissory note dealings, where again documentary evidences are completely present. So, what happens here is when documentary evidences speak and speak clearly, vehemently, why there should be a long drawn procedure of civil procedure? Why can't we have summary procedure? So, this is the idea behind having summary procedures. So, money suits where it is based upon a written agreement between the parties, summary procedures are encouraged. Generally, in summary procedure, the amount demanded is always fixed amount. If the amount needs to be assessed, then the court refuses to take it up as summary proceedings. For the assessment of the amount, defendant needs to be heard. Now, let me move on to the next one. This is the latest addition to the Civil Procedure Code. This was added in the year 2002. There has been a long standing need that court should encourage non-court activities, I mean ADR activities, alternative dispute resolution activities. Now, these alternative dispute resolution activities are the processes where the dispute is resolved by not following actual court proceedings, but the proceedings other than the court proceedings. When I say court proceedings, we are talking about a system which is called as adversarial system. In adversarial system, there are two opponents opposing each other. They would be throwing mud at each other, and whoever is less dirty wins the case. But in ADR, it is an amicable process where the matter is decided based upon the compromise between the parties through an amicable process. 129th Law Commission report recommends the ADR processes should be included as a part of CPC. On the basis of the recommendation of Law Commission and other commissions, the legislatures brought an amendment and they introduced section 89, and under section 89 they have introduced 5 procedures which qualifies to be ADR procedures, and they are arbitration, conciliation, mediation, judicial settlement and lok adalat. So, what happens when do you invoke ADRs? When do you invoke section 89? When a plaint is filed before the court, and in response to the plaint when written statement is filed, the judge has to go through the document and form an opinion as to whether the dispute could be settled or whether it should go through the process of dispute resolution. If the judge feels that this matter could be settled, then he should formulate terms of settlement, the possible terms of settlement based upon the plaint and written statement document, and submit it to both the parties for their observation. So, when it is submitted for their observation, parties need to respond to that, and when they respond to that, based upon the response, the judge would reformulate the terms of possible settlement and resubmit to the parties. So, when this initial act of the judge is done, now judge is fairly sure that the parties are inclined to settle the dispute, only they need some persuasion. So, in that case, the judge would recommend parties for any of these 5 authorities. So, it is the parties who are going to choose these any of the authorities, and if they take up arbitration or conciliation as the process to resolve dispute, then they would be governed by Arbitration and Conciliation Act 1996. So, here they will not be governed by CPC, they go out of the coverage of CPC, in turn out of the coverage of court system. If they prefer Lok Adalat, then they are governed by Legal Services Authorities Act 1987. As per the act, they are still within the grip of court, where the court can supervise the processes. Judicial settlement, again Legal Service Authorities Act 1987 is going to govern the process, and in this judicial settlement process, court has got certain control over the process. But mind you that in all the processes, parties play a major role, because it is a matter of compromise, it is a matter of settlement which parties have to decide, not the court. And last one, if they opt for mediation, then it would go to mediation process, which is governed by the rules framed by the various high courts. The high courts have established and laid down their own rules, and that is going to govern the mediation processes.